improper influence, if not jury tampering, from the outside. And so, we put together a very detailed PowerPoint presentation that we filed as part of our motion for new trial regarding the social media postings of juror number one's wife, and how those correlate to what we believe is a very real belief that that information influenced and was known to juror number one during his deliberations and during the trial. This has been noticed as non-evidentiary, I understand, so I'm going to try to move along. I didn't bring the PowerPoint to run through it since it's been filed with the court, but I do want to lay for the record the timeline of this, because I think if the court sees the timeline of this, you can see that the alarm bells are really ringing. If we go back, even if you start with what we filed as of record, the juror question that was filed on October 12th, with the Sally Smith's name spelled in the SS logo, and we filed that with the court. We're not accusing juror number one of being a Nazi.
Let me ask you about that. Every single juror question, my habit was to read the question at sidebar, and since I'm right-handed, I would use my right hand and turn it over, and almost always I handed it directly to you to look at. And so not only did you hear the question, you had the opportunity to physically look at the sheet, and then about halfway or 2/3 of the way through the trial, your side asked for a copy of all the juror questionnaires. That same day I had the clerk provide them to you, so you had them. So why was this not addressed in your motion that was made? You waited a couple weeks, but then you made a motion to disqualify the juror, but said nothing about this. So how is it that this issue isn't waived even before we get to the merits of the issue?
We frankly did not appreciate the difference in the lettering, Your Honor. Had we appreciated it, we would have raised it.
I don't understand what you mean. You couldn't tell that the S was different than other questions, or you didn't know that this was in your mind, what you're so definitively saying is evidence of juror number one calling Sally Smith a Nazi. So, I mean, what is it?
Well, with respect, Your Honor, I don't think anybody, including the court, appreciated the difference in the lettering in the moment. Had we done so?
Well, your second supplement is extremely definitive. And so I'm wondering, one, why is this issue not waived? And two, what is the good faith basis for the statement and the assertion you made, or actually Mr. Hunter made, in the motion?
What other plausible explanation would there be for distinct lettering for Sally Smith, especially in the eve of Mr. Anderson giving interviews to Court TV accusing the defense of following the Nuremberg defense of we're just following orders? Had this been only an isolated situation where one juror question has different lettering in the absence of any other suspicion of hostility, we may share this court's view that that would be an extrapolation. But
my recollection is that you all made a big stink about Mr. Anderson's interview that next day, and we had to talk about it and discuss it. So I don't see how you can say you didn't appreciate the issue when you physically saw the questionnaire and you were later given it during the trial. So why is this issue not waived?
These issues are, from a legal standpoint, a procedural standpoint, the motions for new trial and requesting a juror review are preserved as long as they're brought within 15 days. There's no legal obligation that we can see that all of these issues need to be timely brought during the trial. Now, certainly, Your Honor, had we appreciated it, we would have added it to our motion. But given the breadth of it, I did not appreciate the different lettering at the time. That's all I can tell you. And it sounds, I don't think the court did. It wasn't glaringly obvious to us as we're reading questions from the bench and focused on the substance of the question.
Well, how did you come to appreciate the difference?
Somebody pointed it out to me.
You can continue.
On October 19th, we put a lot of the social media postings of juror number one's wife. And look, spouses of jurors are entitled to opinions. That's not the issue. The issue is a lot of what's posting here, and I don't think the plaintiff is going to argue in rebuttal that her postings are not extremely pro-plaintiff. That's not even the issue directly here. The issue is, given the hostility of juror one's questions and timing his questions to what she's posting online, gives a very strong presumption that they were communicating. Starting on October 19th, juror number one's wife was posting online about the lineup for the next day that included Detective Stephanie Graham. And then the next day, when Detective Graham's on the stand, she's posting in real time on social media that her husband's going to have questions for Detective Graham.
Well, let me ask you about this. Because anyone who was at the trial knows juror number one was basically going to ask questions. Maybe not as certain as death and taxes, but probably as certain as there's going to be a traffic slowdown on I-4 around the Disney Champions Gate area. So how is that evidence of inside information?
Judge, again, if this is the only instance of juror number one's wife predicting who he's going to ask questions to and when, again, in isolation, if that was the only issue, I would appreciate it. But as we lay out, there's about 15 more instances that combine with it. Again, in real time, I appreciate the court shared the email from the woman from South Africa questioning the integrity of the Kowalskis. We call her the agent, regardless of what she is. She's, you remember Jules in the courtroom. She's been online saying she was texting with Maya, texting with the Kowalskis. She's calling into YouTube blogs and saying what the jurors are thinking. And, that email was shared with the court. The court shared it with us, but as part of the email, when you look at it, she's talking about juror number one shaking his head hostilely towards the defense witnesses, that Jules is calling into the talk show saying that that they're hostile to all of the defense witnesses. And you get to what I think is very glaring was the October 26 questions when Sally Smith's video was played. I'm sorry, when Sally Smith took the stand. If you look at what juror number one's wife is posting online at that point, and she is, again, I don't need to establish the pro-plaintiff bias, but it's concerning to the defense that when you look at her social media follows, it's not just the pro-plaintiff blogs. It's the Take Care of Maya producer. It's Mr. Anderson's jury consultant. And she writes on October 27th, I think Sally Smith only relied on Tampa General to decide this case. At the same time, her husband's asking the same questions that Your Honor may remember Mr. Anderson was complaining to the court. We need to clarify that the 2015 Bonnie Rice call was different than the 2016. When you look at his questions, they are, quote, why would Dr. Rice, a TGH doctor, need to call you, Sally Smith, about Maya when you're over at ACH? And then he asks the second question, why is Bonnie Rice calling you to raise the red flag? They're sharing the same questions and the same concern and the same confusion. Again, when you fast forward.
Well, from a timing perspective, didn't juror one ask the question first and then there were comments from, I don't know what to call it, the public, trying to discern what the question meant?
They were made at the same time, yes, Your Honor.
No, which one was first?
I believe his questions were first.
So assume that the statement was from somebody other than the wife. If someone sitting in the gallery observes a question and then comments in a public forum about the meaning of it or the questioning of it, how does that show inside information with the juror? Because
it's a discrete issue of sincere confusion that they both share on the same topic. And, again, under the totality of the circumstances, as the defense is looking at this in retrospect, it belies credibility that the two of them share the same confusion on the same topic with absolutely no communication. And, because of the time limitation, I just want to fast forward to the part that I really think is concerning. We filed the video of of juror number one's wife sitting next to Jules in the courtroom. Again, this justice system requires not just, obviously, that the jurors be sequestered from outside information, but it requires the appearance that everybody participating in this tribunal is fair and impartial. I find it impossible to believe that, and I'll say it, that the Kowalskis didn't know at that point, because Jules is texting with him and communicating with him, that she didn't just spend the day with juror number one's wife. And that when we made the motion to disqualify juror number one for our feeling that he was no longer fair, that he was no longer impartial, somebody has a duty to let the defense and the court know, hey, by the way, his wife was in the courtroom. She's posting online saying, my new best friend is Jules. She's posting in chat rooms saying to one of the bloggers, check out the burner phone with regard to information we have about the Heart Institute. And they're making plans to go to dinner. I mean, at some point, just the appearance of the foreman of the jury's wife sitting in close contact with the agent of the Kowalskis is wrong. And the idea that this can go on unbeknownst to the defense and known to the plaintiff, that ultimately culminates in a motion that we brought in, I believe, November 6th, asking for the disqualification of juror number one. And Mr. Anderson, as you remember, went back and forth on it. I think I'd have to agree with this. You asked him, in fairness, Your Honor, do you want this as an appellate issue? And Mr. Anderson said, no, I'm going to substitute in the next juror. And then he went to Mr. Kowalski and said, they had a conversation. Obviously, we're not privy to the conversation. He said, based on the conversation I had with my client, I have to go with his wishes and keep him on. At that point, we believe it has to be clear that they knew that his wife was in the gallery. What Jules may have told them about what conversations she had, we don't know. But we're entitled to an interview on this subject to find out.